TVASIatelugu ప్రేక్షకులందరికీ hello and welcome back to yet another fabulous episode of the talk show with the experts. మనతో మన expert Rahul Reddy garu. Rahul garu, thank you so much for being on the show.
Thanks for inviting me.
And I know that ఈ మధ్య ever since the Biden administration has come into power, they've been proceeding like dhanadhan on so many acting quickly on so many issues in Mata, and one of the big ticket items being immigration. And it looks like Biden is acting very fast on immigration related issues, and we wanted to understand what is the scope of it now, because I think as every week goes we understand a little bit more. So if you can just elaborate on that a little bit, that would be great.
Biden administration doesn't want to leave anything to the air. He doesn't think that the Congress is going to act quickly. He doesn't think the Congress is going to work quickly unless he takes the first move. He has seen the previous administration, including the Obama administration, including the Bush administration, including the Clinton administration. He was the senator in those administration. Mm-hmm. So he wanted to act quickly so that he can force Congress to act upon. He already passed executive orders. He wants to redetermine how the things are working, especially when the children are being separated from the families. He wants to redetermine what is going on at the border. He wants to redetermine how the business immigration has been handled. He has passed executive orders to study a lot of these things. In certain cases, he has taken immediate action, especially when the children are separated from the parents. He definitely acted very quickly on it. There are a lot of criticism that is coming from the Congress. Especially Lindsey Graham is criticizing, saying that, hey, give us some time to act on it. Why are you acting on it? Let's have the bipartisan thing, roll it out. And the answer, I don't know, Biden administration, my answer is, Mr. Lindsey Graham, Senator Lindsey Graham, you've been a senator for 25 years. You haven't done anything.
Yeah.
Why are you complaining? So definitely this administration doesn't want to leave it to the Congress. He's forcing, passing the things. He is issuing the executive orders so that he is going to force the Congress, hey, either you act or it's going to be executive orders. I just want to announce one good news, Sandy. Biden administration has postponed the level wages. That means that when the H-1B lottery people apply, it was based on pure luck previously, and of course the master's degree people will get more preference. But in the dying hours, Trump administration has added that it will be based on the highest level of salary, which in our previous shows we explained what it is. But for this year, we are for sure that it is going to be the old system. It is going to be the lottery based on only bare luck, nothing to do with the level of salary. People can start applying lottery system from March 9th onwards, not March 1st onwards, but it's March 9th onwards. So with the same old system, nothing has changed. So that's a good news for a lot of people, especially the students who got jobs and who are able to apply in the lottery system. That's a good news for a lot of these people.
That's actually fantastic news, and given the beginning of the year when we during our first episode for this year, we were talking about how grim things are looking, but now it looks like within a month.
And then in our shows, so we said that Biden had no plan on business immigration.
Right.
Definitely, he did not had any concrete plan. He did not express the plan.
Right.
But the steps that he's taking right now absolutely seems that he has an agenda. And that agenda seems to be falling in line with the merit-based system and falling in line with the people. They are not going to, most probably, they're not going to look into where you're born, but what it is not where you're born. It is what merits that you have will be business immigration. It will be judged on that. That seems to be the way of Biden administration. We have to keep a close watch, though.
Okay, but yeah, good news nevertheless. I guess Biden's not been a career politician just by chance, so he's...
Of course, yeah. He knows ins and outs.
Yeah. All right. On that note, Rahul garu, we have a lot of people just waiting to, ask their questions. So let's take our first caller. So area code 901, we're ready for you now. Okay, while we're waiting for our first caller, we have a question from Annie. She says, my H1 extension will be filed in October. What is going on with the wage level criteria? And I think you kind of addressed that as far as H1 extension is concerned.
Yeah, actually that wage level was never applicable for extension anyway. But now Biden administration has taken the wage level off. Relax, you are fine right now. Okay. And not only, they have also increased the wages too. Trump administration before they went out.
Oh yeah,
that was reversed. Yeah, that was reversed too. So most
of
the wages went by about 25 to 40% though. That was reversed, and now lottery system based on the level of wage has been reversed too. So that's good for both the things for us. It's absolutely good. This administration, I'm very happy with it.
Wow, within the first month, like by Feb itself, we're seeing such a huge.
Right. He came to power on January 20th, not on November, but not on January 6th when the Capitol riots happened. It's on January 20th. And today is February 7th.
Yeah.
This is a man of action.
Right. And it's good to see that. All right. Sir, area code 901, we're ready for you.
Hello, sir. Thanks for taking my call.
Hello, sir.
Looks like I'm in a serious situation due to expired I-94.
Mm-hmm.
At the port of entry, CBP officer given me incorrect I-94 expiry date based on my old I-797. And now it's been more than 17 months that my I-94 has been expired, and also my visa expired. So my question is, how do I rectify the I-94 issue?
One thing I would suggest is do not go to CBP office. Some people do the mistake. They may detain you.
Right.
Don't go to the airport. Don't go to CBP office. I would request you to put the phone off right now and make an appointment with a lawyer because there may be some things that should be discussed personally rather than on the open forum in the TV though. One suggestion, strong suggestion that I would tell you is that do not go to CBP office. There is a good chance they will detain you.
Okay. So my current H1 is due for extension within 6 months. So my employer, they were requesting me documents for extension. So should I talk to my employer attorney firms regarding this?
Before you talk to the employer firm, you may want to talk to a private lawyer though, because there may be certain things you don't want to discuss with your company lawyer.
Right.
Okay.
Okay. Sure. I'll do that.
That's your option. I suggest that you discuss with an outsider. One thing is for sure, I can tell you that don't go to CBP office though. Okay.
Understood. Right.
Okay.
I will definitely make an appointment private. So just in case if my employer does not support me since it's been more than a year that.
That's the reason there's a strategy that need to be adopted where the employer may not even need to know what's going on. There are certain steps that can be done. You may leave the country and that guy can file the H-1B while you're outside the country. That may be the better strategy, but it will be good to speak with a private lawyer rather than in the TV Asia immigration show where 25,000 or 50,000 people are watching. Okay?
Correct. And it's been more than a year that
I got the point. You need to discuss privately with a lawyer rather than in TV Asia with 50,000 people watching us. Okay?
Okay. Thank you.
Thank you for calling in.
Thank you.
All right, Andy. Let's go on to our next caller. And in the meantime, we have a question from 𝗧𝗟𝗪 𝗪𝗧𝗛. Says Rahul V, after 180 days of getting EAD on a 485 adjustment of status, would it matter if I move to a very small company on a lower salary in a similar profession, or should I avoid changing my job? Appreciate your help.
It doesn't matter actually. If it's a smaller company, that's not a big problem at all. Absolutely not a problem. I've seen so many Fortune 500 company people joining the startups right now because they want to explore more options. And that's the reason why 485 is very good. It has a lot of flexibility. You have to be in the same profession. Should you have to draw the same salary? No, even if it's less, by 30, 40%. There's nothing wrong. Absolutely. You can join a smaller company. It can be a lesser salary. That's perfectly all right.
All right, Mr. Harish, I hope you got your answer. And on that note, let's go to our next caller, Andy. It's area code 512. We're ready for you. So *6 to unmute your line. *6, Andy, to unmute your line. All right, while we're waiting, let's go to the next question. This is from Vinod Reddy. He says, in your immigration show on Tuesday, you talked about USCIS receiving 450,000 I-485 applications for 250,000 GCs available this year. So I've applied my 485 on November 22nd. Will all of us get EADs and APs?
It is true that I made a statement of 450,000 green cards. What is not true is that the 250,000 is for everybody, though, not just Indians, though.
Yeah, okay.
Out of this 450,000, I can tell that more than 425,000 are Indians.
Got it.
So out of the 250,000, we may be only eligible for 100,000. I just want him to note it down. The other thing is that once you file the adjustment of status, even if the priority date backlogs, even if the number of people are much more than the green cards that are available, your EAD and advance parole will be processed, will not have any problem whatsoever at all. This happened in 2007. A lot of people who were priority date were current, and it was not current until 2012. They got their EADs extension. They got their APs extension. They changed their jobs by using the 485J supplement. No problem for whatsoever for those people. It happened again in 2012. From 2012 to 2020, the dates did not move. Let me tell you one thing. The final action dates have still not passed the 2012. That is approximately 8 years. They are still getting the EADs. They're still getting the APs. They're still changing the companies using the 485J supplement. No problem. You will get your EAD and AP.
Wow, okay. All right, Andy. So let's go to our caller.
Hello.
Hello.
Hello. Can you hear me?
Yes.
Yes.
Please go ahead.
Yeah. Thank you so much, Rahul Garu and 𝗬𝗓𝗪 for your time. My case is like I filed my H1 extension in July last year. And the H4 for my wife and H4 EAD and my son H4. And my H1 got approved. The H4 is still pending, and they got biometrics in September last year. And I filed EB3 to EB2 downgrade in October, and we received 3 EADs, myself, my wife, and my kid also.
Good for you.
Yeah, but only my son got biometrics appointment, which is on February 17th. But myself and my wife, we didn't get any biometrics. Do we have to worry about it? Because only my son got biometrics.
You should not worry about it, but I want you to make an account in the USCIS, put an alert system in there that anything that comes in, you will get a text message or email thing. In that way, if something happens, you know, maybe the mail doesn't receive it, the alert system will alert you.
Yes, I already did that actually, yeah.
I think you're pretty good. You're pretty good shape. You're fine. I'm not expecting much problem.
Okay, so then another follow-up question. So my son, he's 10 years old now. So my 140 is still pending, EB3 140. So do you suggest to go for premium processing, or should I keep it regular only?
Sorry, I take back my word.
Yeah.
I'm not telling you, but I will tell you what I will do if I were you. Since if my son is 10 years old, I'm going to do premium processing. Now, don't come back 11 years on this TV, afterwards on this TV show saying that I told you, okay? Because I did not tell you. I said, I will do this.
Understood. Yeah.
Okay.
Yeah, and I can go ahead and use EAD, whatever I got. Yeah, okay.
Yeah, believe me, I've gone wrong so many times though. So I'm just going to do what I will. Yeah, I won't tell you what to do. Okay.
Got it. Yeah, ma'am, I have been thinking about it. Yeah, thank you so much for your time. Thank you.
Thank you, sir. Thank you for calling in. All right.
Yeah, thank you. Bye.
Go to our next caller, Andy. And in the meantime, we have a question from GC Aspirant. It says, currently having H1 with employer A till June of 22. Employer B has filed for an H1B transfer and has obtained approval till December of 23. I'm not joining employer B. Any problem if I stay with employer A? And the second question is that he's concurrently applied 485.
Let me first answer the first question.
Let's go with the first one.
If he has the H1B transfer with company B and he doesn't want to join that company, he has no problem whatsoever at all. He can continue working with company A as long as the company's H1B is still valid. He is perfectly safe. Let's go to the next question.
Okay. Question 2 is that concurrently applied for I-485 and 140 regular processing. Do I need to wait for 180 days after getting the I-140 approval to change employer, or is it enough if I wait for 180 days after applying for the 485?
The rule says that you must wait 180 days after filing the 485. The rule is completely silent on how long should I wait on the I-140. However, though, it is strongly advisable that you wait until the I-140 is approved. That is very, I absolutely, if I were you, I will not move out of the company unless I-140 is approved. Now, the second question is that do you have to wait for 180 days after the I-140 is approved? It is not needed. Okay. You can move if you want to. If you move, you can move after the I-140 is approved, you can. So I-140 should be approved for sure, and the 180 days after the 485 has been filed. These two things are for sure. It's optional if you want to wait until the I-140 is approved after 180 days. It's not needed.
Okay. All right. All right. Thank you, Andy. Let's go to our caller. So area code 682, we're ready for you now. Please press *6 to unmute your line. So area code 682.
Hello.
Hello.
Rahul Garu and Nithya Garu, can you hear me?
Yes, sir.
Yes.
Please go ahead.
Yeah. So Rahul Garu, actually, I have a question regarding the I-94 gap. My wife and my daughter, they are on H4. So there was a gap for 19 days in 2018. So between the last extension and current extension. But the current extension, we have valid I-94 until September 2020.
Why is there a gap? Is it because you filed the extension and they gave the extension later on? Is that what you're speaking about?
No, actually, because before the current extension, I went for H1 amendment because I changed the project and I moved to different location. My lawyer
we are only going to speak about your wife and kid because there is no gap for you.
Yeah, I don't have a gap, but based on the amendment approval. Yeah.
Right. So let's say, for example, your wife's, when was the wife's H4 approval expiring though? Date. Give me the
2018, 2018 September 9th.
Okay. And when did you file for your wife's H4 extension?
So I filed ahead of time, but my lawyer actually put the start date on the LCA September 28th on 2018.
Okay. Okay, that's fine. Okay, go ahead with your question. I got the point why there is a gap. Go ahead.
Yeah, because my amendment was approved. I got additional days, and my lawyer started. My I-94 started. Yeah. So what would be my option? Because can we go for visa automatic revalidation just to visit Canada, Mexico, just to again enter into the country to fix that issue, or any other option available for us?
It is still only 18 days of a period that is left out there. Honestly to tell you though, if you pay me consultation fees and come and ask me a lot of different questions, I may be inclined to tell you different things though. Now let me tell you, what are the chances for your wife and your kid to get into trouble because of this 15 days or 19 days that you're speaking? One in a million chance. Have I seen that one chance at all? No, I have not. Right now, if I were you, now this is again, I'm not advising you. If I were you, I would not do anything and I would not panic. In the previous caller, I told him I will consult a lawyer. I would not, if I were you, I would not consult a lawyer.
But actually, I filed the AOS in October, but I'm planning to visit India, but I don't have any visa stamping, valid visa stamping. Just I want to use the advanced payroll. But if I use the advanced payroll while entering in the country, so the provision 245K will not be applicable.
Yeah, I think so. If you want to, you may have to consult a lawyer. If you want to, you may consult a lawyer privately though. You can go outside the country and enter back if you want to resolve the issue.
Yeah, so we will not have any issue, right, in the port of entry, no, because we don't have visa stamping, just I-94 validation. Yeah.
1 in a million chance.
Okay. Yeah.
Okay.
Thank you, Rahul. Yeah, thank you.
Thank you, sir. Thank you for calling. Let's go to our next caller, Andy. And we have a question from 𝗟𝗡𝗙. He says, does the employer have the ability to withdraw downgraded I-140 application from date of filing or 6 months of I-140 approval?
They can withdraw the application. There's no doubt they can. A lot of people are under the conception that once the I-140 has been approved for more than 180 days, the company doesn't have any authority whatsoever at all to withdraw it. They can withdraw. The only thing is that it may have a minimal effect on the person though.
Okay.
For example, if you file the adjustment of status and your downgrade application is there and the I-140 is already approved, and you move on to a different company by filing a 485J supplement, if the current company withdraws the I-140, you're completely safe. Nothing will happen. I mean, if you file the 485J supplement after 180 days, you're completely safe. But if you don't file a 485J supplement, that means that you're not transferring the green card application to company B. And if the previous company withdraws the I-140, the USCIS will look into the file and say, hey, there is an adjustment of status, there is an I-140. The I-140 has been withdrawn. This guy has not filed a 485J supplement. I may deny the 485 application. They may issue an RFE. They may deny it completely. If you have a denial, there are ways to turn around, file a motion to reconsider, or you can even go to the federal court and get it reversed. But my advice is that once the 180 days passed, after the I-140 is approved, if you are changing the company though, and mark my word very seriously, you need to file the 485J supplement. It is not good. It is not safe for you not using the 485J supplement. You're risking yourself and making immigration lawyers rich.
Yeah, and I think you've mentioned many times, it doesn't cost anything to submit that, and so
$0. Of course, lawyers will charge, but the filing fees is $0.
Filing fees is 0. Yeah. So, Mr. Kumar, if you're watching this, then that's your answer. All right, let's go to our next caller, Andy. So, area code 918. We're ready for you now.
Hello, sir. Can you hear me?
Yes, we can, sir. Please go
Hello. Yeah. So I'm just trying to help one of my friends. I mean, the first caller, basically, with a expired I-94. He has been here in the country for more than 17 months. Main question is regarding the dependent. What happens with the dependent? Dependent has not violated anything. She has everything fine. If the primary applicant leaves the country for whatever reason to rectify his I-94 issues or whatever he's doing, what happens with the dependent?
It's a bit complicated though. There is something called unlawful status. There is something called period of authorized stay. There is something called out of status though. There are defined, three of them are defined separately. Now, unlawful status is when your I-94 expires, you are in the country, you're considered to be unlawful status. Now, for the dependent though, they have the I-94, but are they in status? The reason they are not in status is because the main applicant is not an H-1B. H-4 visa is only given to accompany the main H-1B applicant. For example, I, Rahul Reddy, came into the United States on H-4 visa because I am accompanying my wife. That's the only purpose. If my wife violates the H-1B status, and if my wife is unlawfully present in the country, even though I have an I-94 for H-4, it's technically not valid. I violated the status. So it is considered to be out of status. The spouse is considered to be out of status. They are not considered to be unlawful status. They are considered to be out of status. So these are very technical terms. That's the reason to navigate it. I would recommend this guy to contact lawyer.
Okay. Last question regarding the same thing, GC processing. What can he do now? I mean, for the
as I said, it's a very complex issue. It's a very complex issue.
Okay.
I do not want to address this in front of 50,000. We should,
Okay. Thank you so much.
Thank you so much for calling in. All right, let's move on to our next caller, Indy. And in the meantime, we have a question from Sameer Chandra. He says, Rahul sir, I filed the 485 downgrade in October. My previous I-140 was consular processed in 2015. Does this mean they sent my original labor certificate to NVC and I'm not allowed I-140 premium processing?
You can still do the premium processing, absolutely. NVC never received the labor certification though. The labor certification always stays with the USCIS. Now, we are having some difficulties. There are some premium processings that are getting rejected for the I-140. It's just the premium processing though. It's not the I-140. You can keep on refiling it. Right. Even though the I-140 has been done in the consular processing, you can still do the next I-140 application that is using the same labor certification. You can still do premium processing. They may reject it the most. I would still recommend you to filing the premium processing. If by any chance they reject, you can refile the premium processing again.
Okay.
But just because yours is a NVC and it's because of consular processing, you stand no different than every other people who have filed the second I-140 application using the same labor certification. You stand the same chance.
Fair enough. All right, Andy, thank you so much. Let's move to our next caller. So area code 832, we ready for you?
Yes, ma'am, I'm ready.
Yes.
Are you able to hear me?
Yeah, we're able to hear you.
I thought I am ready. You are not Nitya.
Oh my God.
My last name is
Hello,
Reddy.
Rahul garu, Nitya garu.
Hello, Andy. Please go ahead.
Sir, I was able to see the I-94 history in the month of October 2020 when I filed my adjustment of status, sir. But what happened is that now after I got the receipt for the adjustment of status for me, my spouse, and my daughter, I checked the latest I-94. I was able to see the latest I-94. It's still valid, but it's missing the history for both me and my spouse, but it is seen for my daughter. I don't know what to do.
You don't have to worry about it. You're fine. Just because it disappeared online, as long as your record is perfect, not unlike the previous caller where the I-94 violated and all those things, just because the online status, online you can't see the history, you do not have any problem whatsoever at all. You are fine.
Okay, sir. Thank you very much.
Thank you.
All right, sir. Thank you so much for calling in today. All right, and let's move on to our next caller. And in the meantime, we have a question from Sam Reddy. He's also ready. On H-1B, I-485, 200 days, not married, have an EAD. If I lose job and company revokes the I-140, it's been approved for 500 days, I get RFE and do not find another similar job, how to move to EAD and how long can I stay in the US?
If you don't move to a similar job within a short period of time, though, your 485 will be thrown out. So he has all the circumstances good. His I-140 has been approved for more than 360 days. His 485 has been filed for more than 180 days. He has an EAD. But if he loses a job and if he doesn't get a job at all, he can't just use the EAD. I mean, practically, it has to be a similar job. So for example, if I'm an immigration lawyer, I'm a lawyer, and I file the 485 application, and if I lose a job, I have to find another job. The new company has to file the 485J supplement in the legal profession itself. So it doesn't have to be if my salary is, let's say, $80,000, my salary doesn't have to be $80,000 when I join the next job. It could be $40,000.
Okay.
It could be $40,000. And if I'm working for the big law firm and then it's a small, solo, tiny law firm, that still is fine. It doesn't matter now. So salary doesn't have to match. The company can be a different company. Does it have to be a law firm? It doesn't have to be a law firm, actually. It could be a private company that is looking for a lawyer. Some of the lawyers are employed with private companies. It doesn't have to be in the same line. The company doesn't have to be in the same profession, but you have to be in the same profession. So if you don't find a job in the similar profession, you will be, your 485 might be denied.
Okay. And so what about, what time frame would you recommend, Andy, within which he should find another? What would you do? I
will, because the law does not prescribe anything on those things.
Okay.
Definitely, I would say that if it's more than 60 days, it's a danger. I'm not telling that if it's less than 60 days, it's safe. But I would say that if it's more than 60 days, they are in big danger.
Okay. Thank you, sir. All right, Andy. Let's move on to our next caller. So area code 623, we're ready for you now.
Yeah, hi, Rahul. Thank you.
Hello, Andy.
So, it's a, maybe in my mind it's a strange question, but it's more related to speculation I have in my mind. So please help me confirm if it's a speculation or I should kind of worry about it really. So EB3 downgrade, I-485, I'm from that category. October 28th, when was my receive date? And in mid-January, around 16th, I received all of those receipts for me and my wife.
That's good.
I-485 and the whole packet, basically, all the receipts.
Of course.
After that, I've been obviously following your advice, so I converted to premium like the first available opportunity, right? So I sent checks about 27th of January. And in my case, like I have to pay, so it's my checks always, I monitor, right, when they get deducted and stuff like that. So there is something very different from how in the last 10 years, right, whenever I've done premium processing or even the latest I-485, the manner in which it is deducted. And here are my 3 points. So first is the check reached my lawyer on Jan 29th, and I saw deduction on next Saturday, 30th, for both my lawyer and my and for the actual premium processing from USCIS. Never ever, the deduction has happened on the same day. Second, it's always the electronic check deduction. Yeah.
Wait. Your lawyer might have delayed depositing his check. Not a big deal. The question is that, did you write the $2,500 check to the Department of Homeland Security?
Oh, yes, I did, Rahul.
So it's cashed out. So wait. So it's cashed by the Department of Homeland Security. At this point of time, unless I have some concrete evidence, I will not doubt your lawyer just went in and cashed in a cash place, okay?
No, I agree. Just hear out my 2-3 points. I think I have a valid question. I mean, what I'm trying to say is like...
Go ahead with the next one,
yeah. So in previous times, right, always I monitor this so that there has always been a gap.
Tell me what happened rather than the history, though.
Sure. So there is always electronic check deduction from USCIS. This time it is like a paper check deduction. Meaning like it shows in the transaction, in bank transaction, elect check if it's a USCIS deduction, and it tells the name of the USCIS like Dallas and stuff. So this time I just saw like, it's a check deduction plain, like there's no elect check written there. then there is no update on USCIS website for a week. Like even it's not converted from anything to initial review or something.
Let's go to the next one.
Yeah, next one is I don't even see. The next one is I don't since the time it is deducted, the amount is deducted. I don't see any update on my actual status, right? Like initial review or anything. And like I mean generally like at least after deduction after.
So what doubt do you have?
I don't know where the money is gone. Like really is USCIS received the I-140 premium processing or not? It's been a week.
There is two possibilities. One, your lawyer might have stolen it. Two, the immigration has cashed the check. 99.999999% of the time, it is the immigration according to my belief. That much trust I have on your lawyer. That's all I can say.
My doubt is not on the lawyer at all. I mean, I trust him 100% as much as I trust you. It's just that the things have been very different from ever it has been before, like the last 10 years I'm talking about.
You're good. You're good. You're good. Don't panic. You're in a good shape. Let's wait for 2 more weeks. We'll be here. If they're still there, you come back. And it's not that I study everything and I have knowledge. I have people like you who feed me information. Believe me, this knowledge is also very valuable. I give equal knowledge to as much as I study. So right now, you don't have to worry. I think so that it's just immigration cashed it. You're unnecessarily getting worried. That's my belief.
Even though it's premium processing and like, I mean, it's
they're taking
the cash, like,
they're taking a long time to act on the premium processing, unlike before.
Wouldn't it even change the status to initial review? Like
that is normal. Let's not dig into every little thing. Whatever tire moves everywhere. The moon has has a different color today. Let's not panic about those things. Okay, let's wait.
Okay, no, that's all I wanted to hear from you. No worries. Sure. Thank you.
All right. Thank you, sir. Thank you for calling in. Keep our fingers crossed and hope that. Right. On that note, let's move on to our next caller, Andy.
Sure.
All right, but while we're waiting for our caller, we have a question from 𝗧𝗔𝗟𝗞 IT. So he says, I have both H1 and EAD, but not married to it. I'll have to go to the visa interview. If I go to India, can I decide whether to use my advance parole based on the outcome of the visa interview?
You can.
Or I have to inform USCIS that I'll be leaving or that I'll be using the advance parole before I go to India.
You don't have to inform anybody when you go to the consulate though. Mm-hmm. If they reject the visa, you may have a complications. Normally they don't reject the visa though. They issue a 221G. If they issue a 221G, you're good to come back.
Okay.
But if they have some negative comments and deny the visa, that will complicate the whole situation. But 99% of the time, that should not happen. I mean, they will just issue 221G. If they issue 221G, you take the advance parole, you just come into the United States. You'll be fine.
Okay, awesome. Thank you, Rahul Garu. Let's move on to our next caller. So area code 361, we're ready for you.
Hi, Nitya Garu, can you hear me?
Yes, sir. Please go ahead.
Hi, Rahul Garu.
Sure.
Recently I received my birth certificate. It says like a late registration of the birth. In the place of birth, it has both village name and mandal name, whereas my passport has place of birth only mandal name. Will it cause any problem?
I'm not concerned that just because the mandal is there and there the village is there, it will cause any problem. I would also try to look into the alternative documents to be ready with them. I will not provide to the immigration. I will make everything ready. I've written an article on it. If I don't have a birth certificate, what are the things that need to be done? In there it says that get a non-available certificate. In your case, that's not applicable. Non-availability certificate is not applicable. But rest of the documents like a school certificate, if you have a hospital record, if you have an Aadhaar card, if you have a PAN card, if you have election records, all these things, collect them. Don't provide to the immigration. But if they issue an RFP at that point of time, you can explain it to them. And if by any chance they have a doubt about, hey, why is that there is a village name and mandal name? Yeah, that's natural. You can go to any experts and get an advice. I consider to be an expert myself in this particular matter. Officially, the reason is that I'm a lawyer in India too. I know how things work out there. I'm an official lawyer in India too. So at this point of time, I think so you are pretty good. But if you go to our in-law group and look into those documents and try to collect as much documents as possible, and don't provide to your immigration lawyer. He doesn't know it. He will send it because he's not a lawyer. He may not be, lawyer who's a lawyer from India and who sees all these birth certificate issues. Just give him the birth certificate. Don't give him anything. But if by any chance there is an RFE, then you provide the rest of the things.
Sure, sir. The second question, like last week, I accidentally bought some cannabis stock, and after 10 minutes, I realized.
I strongly recommend that people should stay away from these things. That's my strong. Right now, we have not seen any enforcement on the stocks, though. We have seen enforcement on usage of cannabis. We have not seen any enforcement. But my precaution, right now, since it's already done, you cannot undo it right now. All I can recommend is going forward, my recommendation is to stay away from those things.
Sure, sir. I sold them within 10 minutes. I realized that I purchased wrong one. So,
yeah. From going forward, my recommendation is stay away from those things.
Sure, sir. Thank you so much.
Thank you, sir. Thanks for calling in. Stocks and otherwise, I guess. But let's move on to our next caller. But in the meantime, we have a question. This is from Blue Turtle. He says, hi, Rahul. What is the impact of Form I-944 for future investment in property? I filed a 485 downgrade in October.
Nothing. Just because there is a 944, if you want to invest into any property, you want to make any money, that's fine. In the process of you making the money, if you lose the money, that's fine too. Nothing wrong with it. I mean, not everything is guaranteed, is right? I mean, we are, as entrepreneurs, we try to keep the money to make the money. And in the process of it, you lose the money, nothing wrong with it. Just because you filed a 944 and you want to buy any more investment, absolutely nothing wrong with it. Go ahead, proceed with it. Nothing wrong. If you make money, that's good. You pay taxes. If you lose money, well, that's a process. This is an entrepreneurship. Nothing wrong with it. You should not have any effect on your green card application, especially if your family income is more than $60,000 per year.
Okay, that makes sense. And on that note, let's go to our caller, and it's area code 754. We're ready for you now. So *6 to unmute your phone line, please.
Hello, Nitya Garu, Rahul Garu.
Hello, sir.
Yes, sir.
Hello, Rahul, sir. Here is the question, sir. I am on H1B and my with EB2 priority date is 2018 June. And now I got a chance to work in India to upgrade to EB1. I am working in MNC and now I got a chance to work in India for 1 year, sir. So if I were you, what will you suggest? You want me go and get a EB1 or else you want me wait for Biden's per country limit removal?
Here, you are, by going to India, you're not you're not taking that many big chances though. There are two things. If you're successful, we know what's going to happen. EB1 is very good. Absolutely. You don't have any question about it. What happens if you go there and you come back, okay, and the EB1 is not successful? Sometimes there's a possibility EB1 is not successful. It happens very frequently though. But you didn't lose any line. You're still working for the same companies, right?
Yes, sir. Same company and same client, sir.
Yeah. So
in India also.
Yeah, yeah. Now here's, you put a good question. You didn't ask me as a lawyer, why don't you tell me an answer? You asked me a question, what would you do? I like it. That's the way I like people asking the question. Now, based on the knowledge that I have, based on the experience that I have, if given an opportunity, if the chances of success of EB1 is good, I'm going to go to India if I were you.
Okay.
Because
so,
your priority date is 2018.
Right, sir. That's correct, sir. And one more question, sir. Can I ask, sir, if you allow?
Go ahead.
Sir, sir, the second question is, my current, I have a valid visa next year, 2022, September, sir. September 2022, I have a valid stamping. Again, I'm planning to come back in the month of May or June next year. So if I'll be there out of country for 1 year with valid H1 stamping, is there any issue? Are you seeing, sir, here?
Yeah, I see an issue of you coming back in June of next year. The reason is that now you're doing a job in India, okay, or some other country, whatever country it might be. So when you're coming back,
right,
you are telling that you have the job in USA, which doesn't look to be that you have a job in USA. So if you want to come in June of 2022, I would rather want you to apply for L1A visa to come back into the United States, not come back on the H1B.
Oh.
You don't have a job anymore, is that right?
Yeah, I will have jobs, sir. My client promised and my company promised that they will offer me here for the same client.
Yeah. One problem that will come up with is that if you have such long absence for a 1.5 year period of time, and you're trying to come back, the CBP will have a lot of questions though. If you're planning to come back on H1B, the one thing that I would suggest you to do is that file a H1B amendment though, okay? I know you told me that it's there until 2022, whatever time it is. File a H1B amendment, and you don't have to go for stamping. That's a good part. You file an amendment, then when you come back, you tell them, look, I am not coming on the old job. I have a new job. Here is the H1B approval. I have a stamping and you can come back. You don't need to go for stamping. That would be better rather than telling that I still have the same old job that I left 1.5 years ago. It will create a lot of doubts in everybody's mind, and there is a chance you may have a trouble in the airport. For that reason, I would file an amendment and use that amendment without going for stamping and come back into the United States.
Oh, okay. Thanks a lot, sir. Thank you so much.
Thank you, Andy. Thank you for calling.
Thank you, Nitika. Thank you.
Let's move on to our next caller. And in the meantime, I have a question from Vinod Reddy. He says, my 485 is pending. Receipt notice from November. My H4 renewal is also pending. My passport expires at the end of June. Can I renew it right away?
He can. Just because his 485 is pending has nothing to do with his passport extension. And his H1B extension is due.
Okay.
At the time of filing the H1B extension, his passport has to be valid. He told that it's valid until June of 2021. I'm assuming that he's going to file the H1B extension before June of 2021. Then he is fine. It has to be valid on the day you apply, not on the day your H1B expires. And your extending the passport has no effect, none whatsoever at all, on the 485 or adjustment of status or on the H1B extension. You are completely safe to extend the passport.
Okay. Thank you, sir. Let's go on to our next caller, Andy. So area code 270, we're ready for you now.
Okay, sure.
Please go ahead, sir.
Yeah. Hello, can you guys hear me?
Yes.
Yeah, hi Rahul Garu, how are you?
Good.
Yep, so my question is, it is a simple question, but I just need some clarity.
Sure.
So the thing is, I'm working for a company as a full-time employee, and they filed my green card as well. My priority date is August 2018, EB2. I got a better offer from a different company with better pay and benefits, and they're willing to transfer my H1 and do my green card process within 6 months. So my question is, like, after listening to your
shows regarding Biden's immigration changes. What's your advice on changing jobs at this moment? Is it something you advise to hold on, or?
This is a very tough question now. Now, previous caller was not losing anything, but in your case, while you are in between, if something happens, you are screwed up. You have the knowledge of the priority date, and you have better guessing knowledge than I do in the priority date, and history shows that I'm the worst guy in predicting the priority dates. I have proof of it.
Okay.
Nobody can beat me. So in your case, I'm not going to tell you what I'm going to do. Sorry. Keep following.
Okay.
Yeah. But either way, I'm not going to tell that you made a bad decision, but your wife can, but I won't. And I will.
Yeah.
And
I haven't accepted the offer yet.
I know, but
you know,
I will not. I will not tell you what I will do. I will not.
Is it? I wish I would have asked if I were you. I mean, you were me. What would you do?
I already took that question. I already took that question that way, but I am not answering you.
Okay.
I'm not answering you. Sorry. TVASIA, you can't force me.
Okay.
Thank you.
Yeah.
So thank
That's
you.
fine.
Yep. Thank you, sir.
Thank you.
All right, then.
Yep.
All right. All right, Andy, let's go on to our next caller. And in the meantime, we have a question from Sai Hosuru. He says, can we request for FOI for downgraded I-140?
Yeah.
As recently received
That's fine.
I-143. So area code 913, can you please press star? Thank you. All right. So please mute your TV line or your phone line. Okay. All right. So he says, can we request for FOI for downgraded I-140 as recently received my EB2 I-140 through FOI?
Yes, you can. Absolutely, you can. No problem. FOI can be filed for the downgrade application. Also, for those people who are not aware of, it's called Freedom of Information Act, where you can ask for the petition. You can go to online USCIS FOIA. Type this word FOIA USCIS, and you can file an online application. They normally will take about 2 to 3 months to issue the things. A lot of people who don't have an I-140 approval in their hand, or even if they have an I-140 approval though, I strongly advise to file it to get an online. They will send an email of that. Yes, for this guy, he can file a freedom of information for the downgrade application. You will be getting a copy of the petition.
Okay, great. Awesome. And on that note, let's go to our caller, Andy. Sir, area code 913, we're ready for you now. Please press star 6 to unmute your line, sir. Let's give him 1 second. Hello?
Hello, Nithya Garu and Rahul Garu. Can you hear me?
Yes, sir. Please. Go ahead.
Yeah, hi. Hi, good afternoon. And my question was like partially answered, I believe, like in the chat. I just have a question for something like this, okay? My EB2, what do you say, I-140 got approved probably priority date of 2014, August, something like that. And with the recent changes, last year I downgraded from EB2 to EB3 on October, and I got the receipts for concurrent filing of I-140, 485, EAD, and advance payroll, all those things. I'm waiting for fingerprints or EAD cards. But my question is, like, you know, as per I-140 rule, employer has the ability to withdraw or to cancel I-140 after 160 days of approval, right? So is that going to be applicable for the downgrade as well?
You're speaking within 180 days or after 180 days. Which one are you speaking about? It's not 160 days under any condition.
Okay. Yeah, it's a 180 days. Means 180 days of filing the downgrade application, or 180 days of the I-140 once I-140 is approved.
He can withdraw it anytime he wants to. The question is that how will it affect you is the main question though. If your 485 application has been pending for 180 days, if the I-140 has been approved, the underlying I-140 has been approved. If he withdraws the I-140, you're fine. Whether the withdrawal occurs within 180 days after the approval or after the 180 days, it doesn't matter for you. Did you get my point?
Okay. Yeah, so that means like, so this 140 which is approved in EB2, will that count towards the 6 months period, or like, is it counted as a new fresh step?
We are speaking about EB3 withdrawal, not EB2.
Okay.
EB2 withdrawal will have no impact on your 485 application because it's already approved for more than 180 days, so it doesn't have any impact. We're only speaking about if they withdraw the I-140, and if they withdraw the I-140 before it is approved, though, it definitely is a problem for you.
Okay. Okay.
There are ways around it. You may have to go to the court system, get it, but if the withdrawal occurs for the downgrade application before the I-140 is approved, and this is for everybody, a lot of people have filed. If the withdrawal of the I-140 occurs before the I-140 is approved, while your 485 application is pending, your 485 application is in grave danger.
Got it. And I have the same question on this one. Like what, after filing I-140, after 6 months, right? Even if the approval is not there yet, what is going to happen if I want to switch the jobs?
I would suggest you do not. Now, one more time, do not do it. Unless your only intention is to make people like Rahul Reddy rich and the people like that. Wait until the I-140 is approved. We have ways around it. Believe me, it's going to cost a lot of money, and then maybe you will get the approval, maybe you don't get the approval. One thing is guaranteed, people like me will get rich.
Okay. And within this 6 months period, do we need to have the compulsory payroll running on that?
Are you asking a question for yourself or for everybody else?
No, for myself.
Well, when you file the adjustment of status, were you working for this company?
Yes.
Yes, you need to have the payroll running for you in this period of time.
Till I-140 is approved. Right?
Till I-140 is approved and 180 days. Both need to be better. That will be in your best interest. Okay?
Okay. Got it. Yeah. Okay. Sounds good. So thank you so much, sir. Thank you, Nabandita.
Thanks, Reddy. Thanks for calling in. All right, let's just go on to our next caller, Andy. And in the meantime, we have a question from Orange 3612. Says, hello, I applied for a 485 in October of 2020, EB1, and priority date became current for FAD in Feb. I-140 has been approved. My L1A is expiring year end. Should I think to move to H1 considering so much delay in EAD and advance parole?
Now, when did they file the adjustment of status, they said?
485 was in October of 2020.
October of 2020.
Yeah, there's no mention.
L1 is expiring soon. If they are eligible, L1A is expiring when?
Year end, so there's time.
Oh, year end is, okay. So they most probably, they're subject to the lottery system. I would not file a H-1B if I were you. There are some small elements of risks associated with it. I would not, if I were you, to move. I would not move to H-1B. If you filed in October of 2020 and your L1A expiring in December of 2021, there is a high likelihood that you will get an EAD. If by any chance you don't get an EAD, that doesn't mean that you're completely out. You may have to wait for some time to get an EAD, and you cannot work after your L1A expires. I'm assuming that L1A is a 7th-year period. You cannot extend it. There are other simple tasks that you could do if you want to. Get out of the country, stay there for 2 months, and come back and extend the L1A if you want to. But I will try not to move to H1, though. I will not move if I were you, under your circumstances. Now, if it's a different timing, though, than the timing that you're speaking, it's a different issue. I would not do H1B if I were you.
Okay. All right. Thank you, sir. And on that note, let's go to a caller, Andy. So area code 248, we're ready for you.
Hi, Nick. Yeah, I am ready with my question. Can you hear me?
Yes, sir, we can. Please go ahead.
Yeah, thank you, Nitya Garu, and thank you, Rahul Garu. And my question is that I have an approved I-140, and in a week from today, I will be completing 180 days after it's approved. Now, my existing H-1B petition is valid until the 15th March of this year, 15th March. And my employer has already, hello?
Mm-hmm.
Yeah, my employer has already filed an extension, which is also approved. So that extension got approved from 16th March, 3 years.
Sounds good.
But I am thinking of changing a job due to some reason. So is it suggestible to change the job at this juncture?
That's fine. I mean, nothing wrong. You have an I-140 approved, and I'm assuming that you're going to wait for 1 week before you announce anything. So it's going to be 180 days.
Yeah.
You're pretty safe compared to, I mean, if you want to change the job, this may be the right time. Nothing wrong with it.
Yeah. So do you suggest to go for a premium, and do you also suggest to hand over both the approved, I mean, like,
you can,
for example,
you can hand over both the H1 approvals to a new lawyer. He can show both the things. Nothing wrong with it.
Okay, that sounds good. And just a follow-up question for the dependents as well on this. So dependents biometrics was done on Thursday of last week. So only my wife's status is updated in the my case status, but not my child status after the biometrics is done.
Call the
is that normal?
Number. It may be normal, but I would call the 800 number to make sure that it's updated properly. That's number one. Another precaution that I would suggest you to do is that make sure when you file the H1B extension, H1B transfer, file for the H4 also.
Yeah.
And the reason I tell H4 is that sometimes what is happening is when you move to company A to company B, the company A withdraws the H1B. The officer is looking into the H4 application and looking that, oh, this H1B is withdrawn. Let me deny the H4 application. And now you're past March 15th, your wife I-94 expired, she is unlawfully present in this country. But if you file an extension with the new company that you're going to join, you'll be in a much safer position. You may have the previous approval, that's fine. You may have the previous approval for the next H1B also, but it's better to be filing one more H4 for your wife and kid rather than risking them to be out of status.
Yeah, sure. So maybe I need to communicate this to my, would-be employer. Okay.
That is right.
Okay,
thank you.
Okay, sounds good. So you just one thing, you said 800 number. Is that something available in the USCIS website?
Yeah, it's in the USCIS website. Is there?
Okay. Yeah, sounds good, sir. Thank you. Thank you so much.
Thank you.
Thank you, Nitya Garu. Bye.
You guys can even try to chat with Emma also on this one. We've been noticing that Emma is getting very powerful and very good. Emma is the bot, but I love Emma. She's very good. Has been very good. So instead of calling and waiting, you can chat with Emma to see if Emma could respond to you. If Emma doesn't respond, call the number.
Gotcha. So Emma is the way to go now. All right, guys, so many questions and so many callers. I feel bad for doing this, but we're all out of time for today. Rahul Garu, thank you so much. As always, you've been very, very informative. And I think we need to come up with a new caption for you, WWRD. What would Rahul do? In order to answer a lot of these questions. But sir, thank you so much for helping so many people out. We really appreciate you giving us your time. And we hope to see you all next week, Andy, back at the same time, same channel, same show, and get your questions answered as much as possible. We try and get through to so many people, but wish you guys a great rest of the weekend and a great rest of the week. And we'll see you back on Sunday. Rahul Garu, thank you again.
Thank you very much.
Okay.